Well, it was a tense morning here at the National Assembly complex as security operatives prevented Senator Natasha Akpoti-Uduaghan, the Kogi State lawmaker, from entering the complex. Flanked by her supporters and journalists, the embattled lawmaker had decried what she called an unconstitutional denial of access, maintaining that her suspension had been set aside by a valid court ruling. While Natasha stood locked out, plenary resumed inside, with the Senate announcing plans to hold a special valedictory session on Wednesday to honor former President Muhammadu Buhari, who died in London on July 13 at the age of 82. The Senate President, Godswill Akpabio, also used the platform to debunk reports that 12 new states had been created under the ongoing constitution review. Senate President Akpabio had clarified that while there were proposals, none had passed the rigorous stages required for state creation. Also, the Red Chamber has approved the federal government's external borrowing plan for 2025 to 2026, which includes loans totaling $21 billion, 2.1 billion euros, and 15 billion Japanese yen, among others, for key infrastructure development projects. Additionally, lawmakers gave the green light for domestic bond issuance worth $757.9 billion to offset outstanding pension liabilities, among others. These are the details here from the National Assembly. More details coming to you in subsequent bulletins.
Ibrahim joins me now. He was at the scene of the drama as well as the Senate plenary earlier in the day. Sagir, it's good to have you here tonight. Please, if you can give us a sneak peek, should I say, into what transpired at the National Assembly complex earlier today.
Thank you so much for having me on tonight. I will start by mentioning that it was just a few days ago on Saturday on Breakfast Extra that we had the conversation about expectations about Senator Natasha Akpoti-Uduaghan's resumption. Well, I would say, Mazino, here you are to have your answers. It's been a day filled with drama. Of course, as we saw, the suspended lawmaker attempted to resume like she promised that she would when she was interviewed during the commissioning of some project at her constituency, Kogi State. And like she mentioned, there you see how the visuals are done in white, as she always does, approach the gate of the National Assembly with the expectation that she would be let in. But sadly, she was denied access with her vehicle. She alighted the vehicle in spite of that and made her way to the entrance of the National Assembly on foot, and also with supporters around her, activists, constituents, and other supporters and well-wishers. Interestingly, we saw individuals who did not even expect to see her there start to sing chants the moment that they noticed that she was the one. But sadly, she got to the gate and she was turned back. Unfortunately, she was denied access. But it didn't stop her from making a remark. It didn't stop her from mentioning that to the world, it has been seen that she had made attempts to resume, considering the fact that a court had delivered a ruling stating that she be allowed to resume, or rather her suspension be reviewed because it seemed to be excessive. 6 months is such a long time for a lawmaker not to, assess the National Assembly, the Senate, or the House of Representatives, as the case may be. You should bear in mind that it takes just 180 days in the legislative calendar for lawmakers to sit. And if you calculate the days off and on, plus and minus weekends and plus days that they go on recess, it totally amounts to almost the entire year that they would sit. So which means that the people of Kogi Central may not be availed proper legislative representation there in the National Assembly. But then she made her mark, she said her mind, she said the Senate President, whom she accused, is making all attempts to ensure that she doesn't resume, in earnest. And she also insisted that she will be going to the Court of Appeal for an interpretation of the judgment of the Federal High Court to ensure, that it is interpreted properly, and so as for these issues to be quelled once and for all.
Well, Sagir Ibrahim, thank you very much. It is indeed a long time for a senator to sit out, but even longer for the members of her constituents. Thank you once again. Now, to take further this discussion, we have joining us now from Abuja lawyer Barry Kingdom. Thank you very much for joining us, Barry Kingdom. So only the Senate and the senator in question appear to have sharply defined opinions on the contested court ruling. But for many Nigerians, there's an ongoing debate as to what the judgment really said. So please, if you can help us answer, did the court say Senator Natasha Akpoti-Uduaghan can be reinstated?
Okay, thank you so much. Good evening, Nigerians. I don't know what happened today at the National Assembly. It's another show of shame. It's another exhibition of lawlessness, the Senate under Akpabio leadership, has always been thrown in the bad light. It is the same Akpabio, that told Nigerians so embarrassingly, we have sent prayers to your mail. People should keep protesting while we are enjoying. Akpabio has shown gross incompetence, to be the Senate President of the 10th Senate of the Federal Republic of Nigeria. What happened at the Federal High Court has rested the issues that were before Honorable Justice Binta Nyako. The matter is now res judicata. Declaratory judgments are valid judgments of any court of competent jurisdiction. Let me cite you one case law, Dalori versus Sediku. It's 1998 case, 12 Nigerian Weekly Law Report, part 576, where the Court of Appeal, relying on several judgments of the Supreme Court, held that declaratory judgments proclaim the existence of legal relationship between the parties. That even though a declaratory judgment did not make any order that can be enforced against the defendant, an order made in a declaratory judgment is valid. That is not devoid of any legal effect. That the controversy between the parties in a declaratory judgment is thereby determined and becomes res judicata. When we say a matter has been determined and becomes res judicata, means that whatever the judge has declared in a declaratory judgment, even if the judge did not make any consequential specific order, as to say Natasha is hereby, the Senate is hereby ordered to recall her immediately. Even though the court didn't make any such consequential order, the court has declared that her suspension is excessive, unjust, unconstitutional. When something is unjust, is illegal, ab initio, is unconstitutional. So the court has made a declaratory judgment without making a consequential order. The only effect for all the parties is to respect the law in the context of what the court has declared that it is unjust and excessive. So if the court has declared that it's unjust and it's excessive, it means that it is illegal, unconstitutional.
Now, Mr. Kingdom, just a second, Mr.
Yes.
Kingdom. So I understand what you're saying regarding this, and it seems like whatever the court orders are is being referred to or regarded as obiter dictum. However, the senator's attempted resort to self-help didn't bring her closer to resuming her legislative duties. Now, is this always the case, that a legitimate ruling of the court is not being seen or is not bringing us closer to a resolution or a major national standoff, a major national standoff? Are we disregarding the courts at this point?
I'm saying that a declaratory judgment has rested the matter. The matter is res judicata. If a court of competent jurisdiction has declared an act unjust and unlawful and excessive, the implication is that it's unlawful. So if Akpabio is a law-abiding citizen of Nigeria, a law-abiding Senate president, he should allow Senator Natasha to resume sittings at the Senate pending when a court of competent jurisdiction, that is the Court of Appeal, will give a better interpretation and possibly overrule what has been declared. In fact, there's no court of competent jurisdiction that can grant stay in a declaratory judgment, because in the case of HO versus Abubakar, part 1261, the Court of Appeal, also citing several judgments of the Supreme Court, held that to grant a stay of execution in a declaratory judgment is to pass that judgment without going on appeal. So the declaratory judgment states what the law is. It states the issue, proclaim the issue before the parties. So what I'm saying is that if they have gone to Court of Appeal to seek clarification as to what is the judgment of the Honorable Justice Binta Nyako, they should conduct themselves within the ambits of the law by allowing Senator Natasha to resume her duty while they are in the Court of Appeal. They cannot sit and become lawless by barricading the door against her, not allowing her to enter into the Senate and to resume her duty, because a court of competent jurisdiction has declared whatever they have done to be unjust. If it is unjust, it's illegal, it's unconstitutional. So the fact remains that in the eyes of the law, whatever happened in the Senate, where Akpabio himself, who is a respondent in Natasha's petition, presided over the plenary, where he put a voice vote, and the senators of the Federal Republic of Nigeria voted against Senator Natasha and suspended her for 6 months, is illegal.
All right.
Senators of the Federal Republic of Nigeria sat like vegetable.
We have to draw the curtain on this conversation, but we do get all you're saying regarding that. Thank you for your submission, sir. Thank you.